takes the assets. So we tend to stay onshore, equivalent protection onshore that you can receive. So that's why we use the strategies we have here. Do I want to use charging order protections? Absolutely. Setup should have charging order protections. It does start at noon, okay? So if you hear it going on now, this is just because I logged in early. We're going to start here at noon. It does officially start now. Great. I've got some people on here to answer that for me from my staff. What comes to real estate flipping, express use corporations, which is awesome. Just excellent. Well, hey, it's noon. And let me just take this link down. I'll put the link back up a little bit later when we go into it. But guys, thanks for coming on. This is the first time I've done this, as I stated earlier. And I really wanted to take some time. I sent out that poll to find out what the interest was. Was it just in protection in general for real estate investing to go through the gamut, the condensed version, or did you have an interest in learning about anonymity? And about 6% of the respondents said they wanted to learn about anonymity. And I can't fault you for that, because anonymity is so important when it comes to protecting your assets. And this is something that a lot of people fail to appreciate, the importance of anonymity with real estate investing. I deal with attorneys and other professionals on this all the time, that they don't see the value. They say, well, if you have an LLC, what's the big deal? If you're going to be protected, why do you need anonymity? Well, the reason is this. I don't want them to sue me to begin with. If I create a perception that I do not own anything, then it lessens the likelihood that accreditor is going to take an aggressive posture against me when it comes to any type of litigation. So one of the key terms that we often use is, and this was coined by my partner Toby Mathis, is he said, Clint, think of it this way: you can't sue what you can't see. And there's just so much in that when you think about it, that if people perceive that you don't have anything, then they're not going to be suing you. I mean, you take what's going on in society right now. Let's say that you had someone that you went out to a rally, and there's somebody there that decided to join the rally. They're a rabble rouser. They live on the streets, and they come there, and they're just there to create problems. Right? And they assault you. They attack you. Well, what do? Do you go find an attorney and say, I want to sue that guy? He lives in that tent 2 blocks away. Let's go to him. And here's what I'm going to do. I want that cooler that he has, and I want that orange sleeping bag, and that grocery cart is something else. That's not going to happen. So yeah, I will put the link back up, by the way. So the thing is that with entity, what you're looking to do is create that perception around yourself. So when people look at you, they don't think that you have assets that are worth going after. And that's how you can create the structures. Now, is it impervious? No, it's impervious, but it works extremely well, and it relies on the fact that most attorneys are not going to dig as deep as they need to. And sometimes I'm afraid to tell all these strategies and give away the secrets, because I'm actually educating the other side on what they should be doing when it comes to looking for someone's asset. I'll give you a great example here before we start drawing some stuff out. You've probably heard me tell the story about one of my clients, nightclub owner, and he was involved in that multi-million dollar, $15-20 million lawsuit where 2 patrons got pinned up against a nightclub by a car, and one of them lost both legs and the other one lost one. Well, just to fast forward to that, because you probably heard on my other videos how we protected the client because they couldn't find anything in his own name. Well, his father, who owned the building, cut down the assets in his own name because everything was in his own name. And I'm going to do exactly what I did for that particular client in LA that saved his bacon. Because they saw that the father had all of this real estate fused, all right, to take his policy limits. Because they said, you know what, you can afford to pay. Your son doesn't have anything, but you do. Now, they ended up taking a judgment against his corporation because they did a title search and they saw that this property, this building, was in the name of the corporation. Well, they took this judgment against him, released this individual from the lawsuit, and then about I don't know, 6 months later, this individual, the father, called me up and we were having a discussion. He said, they want this much money. My corporation's obligated to pay them. They took a judgment against the company. What should I do? Well, I looked into it and I said, your corporation doesn't own the property. That property was transferred out 9 years ago. I don't know why they took a judgment against this corporation. And he said, well, then what should I do? And I said, well, you have no assets. Pay. They basically accepted judgment against a company that is defunct. There are no assets there. Now, why did they make that mistake? Because they did such a poor job of a title search. They didn't look deep enough to determine where that property was actually held, and as a result, they missed out. So that's what I mean with anonymity. Attorneys many times perform a cursory examination and they don't know where to look to determine where the assets are being held. So we want to use strategy. So what do we use then to create an anonymity structure? Well, there's a lot that we can use. Let me just take this down and bring this up. But there's some core entities here I'm always going to be working with. First off is that we want to start with a structure from an asset protection standpoint. We want to use the state to create our LLC that provides anonymity. Now, we have a lot of clients that come to us to set up structures for them, and they're real estate investors, and they've already done some of this on their own. Let's say they come to us and they have an LLC set up right here. This is a Florida LLC, and this one over here is a Georgia LLC. Now, if you've set up your own businesses right now, if you've set up LLCs to hold your rental real estate, then you know exactly what I'm talking about. When you create your limited liability companies, you had a choice. You could set them up as either a manager-managed LLC or a member-managed LLC. Now, the difference between those two is that in a manager-managed LLC, you have the control of this appointed to this manager over here. Okay, this is your manager right there. So your manager is in control of the liability company, and then you're down here as its member. So in a manager-managed LLC, this person is going to be listed with the Secretary of State. So if I looked up Georgia LLC and this individual here is Susan, then it's going to read Susan is the manager of the limited company. So then I can figure out, who's really involved just by searching Susan's name and find out where she lives. And it gives me more coverage, all right, in that lawsuit. Maybe I even name Susan as a named beneficiary in the lawsuit. So that's a problem. Now you could opt for another form, which is called a member-managed limited liability company. And that is where we don't have a manager, but we're going to give control over here to the member. So if Susan was the member, then Susan's information is going to be there and it's going to say she's the member. Now, what does that mean to a third party? Well, she's just the manager that tells us she has control. We could assume that she may own it, but we know she has control. When you tell someone that you're the member manager, I know right away you own it and you control it. And maybe Susan is John. So if John and Susan are both members, now both information is listed on the Secretary of State's website. So when you create like this, you're putting all of your information out there. And many times what I see is when you create an LLC, you have to have a registered agent, right? An RA, that is someone that can accept service of process on your behalf. Every entity must have a registered agent that has a physical address in the state where you're creating the entity. And it either has to be a business that has normal business hours or it has to be an individual. So if Susan wanted to set up her own entity, be her own registered agent, you can see how many different ways now we can find Susan, and I know what she has. So that's an issue as well when you're creating entities. If you're looking for anonymity. If you're going to be your own registered agent, you've just blown it there. The business address. So many states will ask for business addresses. Well, Susan does not have a business address. She only has her home address. So now, entity, you list her home address on there. You see how many different contact points now we're creating when we file this entity. There's no anonymity that comes from. So we have to be careful when we're creating these structures. If you're trying to set up a structure where people cannot trace this back to you, and when I say anonymity, we're not hiding from lenders, we're not hiding from the IRS. The only person we're keeping our information private from are predators who are looking to use leverage against us to force us to meet their settlement demands. Because that's what they're going to do if they have this information. So rather than start with a structure like this, where you're creating the LLCs in the states where the properties are located, what we will do then is set up a structure where we begin with an entity here that's typically filed in Wyoming or Delaware. I know people have talked about New Mexico. They've asked me questions about that before on my YouTube channel. And you may have heard of Mexico as being a state that offers privacy. Granted, it does, but I'm going to explain why I don't use that here in just a moment, why I'd like to go with Wyoming and Delaware. So the key about the Wyoming and Delaware situation is that when you set up the entities in either Wyoming or Delaware, they don't ask for the member or manager entities. That information is not requested of us. All they want to know is, what is the entity? Who is a registered agent? Again, it's not going to be you that you're going to use. If you're using us, we're the registered agent for our clients. So they want to know who the registered agent is, and they want to know a business address for that entity. Again, if you're using us, we're giving you a business address at either our Nevada office or our Wyoming office. So as long as you provide this information, you can set up an entity in either Wyoming or Delaware that doesn't list any of the managers or members' information. So this Wyoming entity could be manager managed, it could be member managed, it doesn't matter. No one's going to know because the state is not collecting that information. Now, you've probably heard Nevada, and there are companies out there that promote Nevada to this day as the best state to set up your business in. The problem with Nevada is that when you use or you set up a Nevada LLC, they collect information on the manager. Say it was manager managed. They want to know who the manager is. But Nevada offers you the ability to use what's referred to as a nominee manager. And we used to do a lot of these entities. So I'm speaking from years of experience here. So when you would set up a Nevada entity, what we would do is we would nominate my partner, Toby Mathis. He would serve as the initial manager. So Toby would be as the manager, so his information would get submitted to the Secretary of State. Then he'd resign his position as manager, and then our client would step in as the undisclosed manager. Now that's great. So if somebody looked up this Blue Box LLC right here with the Secretary of State of Nevada to say who's in control, who's hanging out with it, it's going to show this guy named A.T. Mathis. It's never going to show Susan down here because she's masked by Toby's information being publicly available. Even though he resigned, he has no control over it. The problem that we ran into about 5 or 6 years ago is that banks quit allowing individuals to open accounts where there was someone else listed with the Secretary of State. So our clients that had Nevada, were set up Nevada entities for them, they couldn't get an account, Bank of America, Chase, Fargo, whoever they're going to, because look online, they would say, who's this A.T. Mathis guy? And then you can only imagine, right, what you would say. Well, that's an attorney in Las Vegas. Well, why is he on your entity? Well, because I don't want anybody to know that I have this entity. Well, why don't you want anybody to know the entity? Because I'm doing stuff I don't want people to know about. Well, what are you doing that you don't want people to know about? And it's in Vegas too. We know a lot of bad things happen in Vegas that people probably don't want people to know about. And so you see what happens? Those wheels start to turn in their mind. This became a structure that was not workable for people, and that's why we really don't use it any longer in our structuring, and we switched over to Wyoming and Delaware because they don't collect any information. So when you apply for your banks, you got to have a bank account. When you're setting this up, they'll look on Wyoming Secretary site, Delaware Secretary of State site, and they won't see any information listed there because it doesn't collect any information. And then you can proceed forwards because then it'll ask you. Now, like I said, you got to have an RA in that state, address there as well. Doesn't relate to you. Why am I choosing this as my base entity and not New Mexico or some other state? Well, it comes down to charging order protections. Next Saturday, we'll go deep on this and the benefits of why you want this. Real quick, shallow aspect here. With charging order protections, what it does for you prevents a creditor from getting up into your business and taking your stuff or complicating your life, taking control of your assets. New Mexico does not offer strong charging order protections. Plain and simple, a creditor can foreclose on your interests. And so that's why We do not the New Mexico side. I mean, I'll use it in limited circumstances, but not in the circumstances like this, because this is the key piece of what it is you're doing. So now from here, what do we do? So this entity set up, let's say that you're the manager. We'll typically set this up as a manager managed LLC, manager managed. And you're also a member down here as well. So you're both still manager managed, manager managed company. Okay, so we got this one LLC set up. And so this is on the real estate side. Now, all I'm going to use this entity for is to hold my other businesses. I don't want people to know how many LLCs that I have. So then when I want to set LLC in Florida or Georgia, I will then go out there and I will set Florida Limited Liability Company here. Here's my Florida LLC. Remember, there were two types of LLC set up. One was managed, the other was member managed. Okay, so those are the two types that we have. So of these two types, if I chose manager managed, it's not going to do any benefit. It's not going to give me any benefit because I would have to then list a manager. And if that's going to be me, then my information's disclosed. Now you might be thinking, okay, Clint, simple. I'll list this LLC as the manager. Well, the problem in listing this limited liability company as the manager of that LLC is that now you're asserting that the Blue Box is actually doing business in Florida, that it's managing a company, engaging in active activity there. And that requires you to register there. So it brings it to a little different level. So that's one reason why we typically don't do it. So what we prefer to do then is make it a member managed LLC. So in the member managed LLC, we're going to have the Blue Box as the member of the Red Box. So when we file our statement of information, we have to list out, actually in Florida it's on the articles, who the member is. I will provide them the Blue Box information. So if we set up a company called Blue LLC, when you file it in Florida and you list it as member managed, you're going to list out there Blue Box LLC member. And that's nothing else is going to be provided to the Secretary. So this is how you build this structure around your entities to keep people from knowing your involvement. Now here's something else that we do with our structures that we made this change some time ago. You set up this type of structure where it's a member managed limited liability company, then how to control it in Florida? If you know, because it could be difficult. Every time you want to sign something, here's how you would have to do it. Clint Coons on behalf of LLC as the member manager of Redbox LLC. All right, just by saying that, my fingers start to hurt because that's a lot to write out. So what you could do instead is set up your LLC that and include in the operating agreement that you have the authority to appoint officers of your LLC. And these officers can transact business and manage the affairs of the LLC on the LLC's behalf. So what we build into the LLC operating agreement is that there's a president, vice president, treasurer, and secretary. We give you 4 officer provisions. And if you're an officer, we'll just make you president over here. You don't even have to sign things now. Clint Coons, manager of Blue Box LLC on behalf of Redbox LLC as its member manager. Now what do? Redbox LLC, Clint Coons president. Boom, simplifies things. So it makes it a little easier for you to conduct business. That information, not publicly available. States do not request it. You don't have to provide it because LLCs, to have officers, that's within the operating agreement. It's completely optional. So as you continue to build out your structures, you keep doing the same thing, just like this. All of these LLCs point back to this one Blue Box limited liability company. Now, previously what I described was a situation, maybe you're listening in right now and you're saying, well, that's cool. I already have an LLC that I up in Colorado. And Clint, I want to get with you guys at your firm and I want you to create an anonymity structure for me. And I want to take that other LLC that I have that I've set up over here in Colorado that has my name all over it. When people look at it, they see me, and I don't want them to see me. Or Rhode Island, wherever it is, get my name off of there. And I want to bring that LLC under the Delaware LLC that you've set up for me. So now I have anonymity for that existing company. You might be thinking what you'll do is you'll take this LLC and transfer it. That would be a mistake. And here's why. Because when you move that interest into that blue box, make the blue box the member manager of that. And I would assume that that was originally a member managed LLC. If it's not, what you would have to do is change actual articles. You'd amend your articles and change your operating agreement, go from manager managed to member managed. That would be important as well. But if you tied in this existing company to your new entity, you're going to then create a situation where you're exposing your future planning. And if you don't see it, I'm going to show you. So on this initial entity that was set up, okay, we've got Sunny. Okay, so Sunny set up this initial entity, and it was under your name. And now you want to get your name off of there, Sunny, and you want to put in your Delaware LLC or YLC so that you're no longer associated with it. The problem is that Sunny is still listed Secretary of State. So if I pulled up this entity's information, if this is ABC LLC, if I went and I looked at ABC LLC and I wanted to look at who the other managers or members are in its history, what I'm going to see is this. It's going to say Sunny, and then all of a sudden it's going to say blue box right there. Okay? So I get this out, right? Sunny then transferred his interest into the blue box. So now you've heard me, the proverbial saying is, the camel's nose is in the tent. What are you going to do? How are you going to get it out? He's just going to keep it in. So once I know that Sunny was associated with this company, and this company is now owned by this Delaware LLC that's not associated with him, but I'm going to make that a connection. Then I'm going to take this entity and see what else it owns. Well, if you're heavily investing in Rhode Island or Florida, well, then I'm going to look to see if that company is on any other entities there. And if you put all the new ones up the right way, you see what has happened here? You've actually exposed everything by taking your existing LLCs and tying them in. So you in a situation like that, is it hire Anderson to come in and redo all of your work? Well, heck, we're attorneys. We'll take that work on. Absolutely. No. You can't, I wouldn't do. Here's why. Because your property's already in the name of the LLC. To get it out, you have their deed. You have to open up new bank accounts. A lot of heavy lifting there. So the way we protect this situation is rather than start all over for your existing LLCs, we'd say, well, you probably need new operating agreements. It wouldn't be at the level that I would like to see times. But what I'll do instead is I will create what is called a property trust, or PPT here. We'll create a personal property trust that doesn't have your information associated with it. And the way we'll structure it is that now we'll change the member to this personal property trust that gives you anonymity. Granted, it's not as strong because you're still listed there. So what you see is Sunny, and then it says PPT, Personal Property Trust. It's like a land trust. And again, I'm going to cover land trusts here. So if you're waiting to hear about land trusts, we're going to get into those. I just want to lay the business framework down. Your land trusts are going to be held by your LLCs. So we got to understand this component right here because this is critical. Now, that personal property trust, similar to a land trust. It doesn't have to file a tax return. It's just there. All it does is give you this anonymity, gives you no asset protection. We have the personal property trust held by the Delaware Limited Liability Company. So we're still able to take that existing red box and get it into that blue box. And there's other reasons beyond anonymity here why you want that blue box there. That charging order is important as well. We want to have that charging order protections. Your state may not offer charging order protections. Next Saturday, we're going to discuss the differences between states that provide charging order protections and those that do not. So you'll get a list of all those states and if you're in what we call a weak state. So we've got this personal property trust here. It's going to provide that level of anonymity. So we can take existing entities and couple them back in to your blue box. So that we go about working with new and existing. But this is the key. This is the key right here. You got to have that structure in place. Now, this is strictly for these LLCs that are involved in real estate. If you had other assets that you want to provide anonymity for. Maybe it's an active business interest. You got to think long and hard. I'll have people approach us and they'll say, well, I want an active business, let's say a business, and I don't want people to know that I own the business. Well, an active business, part of that business is based around you, right? And you're going to go out there and you're going to market it, and they're going to be hiring your business. If you're the one doing the work, they're really hiring you. So anonymity isn't that important there in that context, because people can draw that conclusion there on their own that it's your business, and you're probably telling them that it's your business. So for active businesses, we're not necessarily always going to adopt this type of structure. We may, depending on the business, if it's not about you. So my client in California, the one able to walk away without having to pay anything other than his policy limits, here's what we did with his active businesses, because he owns a number of nightclubs. Now, of course, when you're in that type of space and that type of business, you're not going to be the one that is out there, being the DJ, saying, hey, this is my club. What do you guys all think? I mean, maybe some younger people might, but most business owners, we just want to sit back, hire people to do the work. We sit back and make the money. Now, he had these clubs. So what we did is we set up a blue box here like this. Then we created red boxes in California like this for the various club businesses. Now, all of these red boxes that set up, so these were active businesses. They had clubs inside of all of them. Club. They were set up to be treated as corporations for federal tax purposes. So they were all like this as well, right? And the reason we did that is that I wanted separate tax returns for each business enterprise. Because I wanted to sell one of the clubs, you have to have a separate tax return, a separate set of books to sell that club. If you combine them all together, it makes it very difficult for the buyer to discern what they're actually getting. They think that maybe you're hiding a club that's not producing by shifting, income from one club to the other. So you want separate tax returns as well. But when we set them all up, we had all the clubs owned by this one blue box. And they were set up as member-managed limited liability companies. So when the lawsuit hit, they were coming after this company here. They didn't know that these companies over here, that he owned them, they didn't even know that he was involved in all of this. They sued the club. The attorney responded on its behalf. We'd protected his assets. And actually, this isn't fully accurate here. I messed this one up. When we did his club separate, that was his real estate side. We did it like this. We created separate blue boxes just like that for each club. So in his case, we had multiple blue boxes. And the reason why is I wanted to make sure that if anyone came into these companies, they wouldn't see his relation to these other clubs through there. He has multiple ones that people did not know about because of the way it's set up. So anonymity from a business context, there's just ways to slice it. It really depends on what it is you're doing. So that's how we create the basics for the asset protection. Now, how do we go about holding real estate? Well, you could transfer your real estate directly into one of these LLCs, right? And if you did, if I put a house over here into this red box that is set up to be owned by the blue box, I have anonymity. There's no doubt about it. Because if you looked on title, what you would see is this property is owned by this red box right here. And if you looked up the red box, you would see the red box is owned by the blue box. Your information is not going to be publicly available. You're in the chain of, granted, people always ask me this at our events. They say, well, Clint, I'm in the chain. So don't they know because I'm in the chain of title that I'm somehow associated with these LLCs? I mean, I understand the question and the reasoning behind it. But if you really think, though, there are a lot of people in the chain of title of that property. So when you sell your house to someone else and they now put that in their name, does the creditor think that that property is really owned by the previous seller? No, they assume it's owned by the person currently on title. So there's lots of people in the chain of title. So by moving your property into the LLC, you gain anonymity. Some individuals are not comfortable doing this, and there's reasons why. Number one, you're concerned about the due on sale clause, that if you transfer real estate from your name into a limited liability company and a lender discovers this, then they could accelerate the note, right? And force you to pay off the mortgage or refinance the property. I get it. That could happen. Now, in 20 years of practice, I haven't seen it very many times. Okay, typically, it all has to do with owner error, meaning the person that owns the property quit paying their property taxes, didn't insure their property, or more likely than not, quit paying their mortgage. And that was the catalyst for this to occur. So if that's a of yours, then this isn't the route we're going to go. The tool that we can use then to help get the property in there is going to be a land trust. Other concerns that people have, property transfers, so transfer tax. If we were to put the property directly into the limited liability company, you're going to get a tax. For example, a good friend of mine is an attorney in Gig Harbor, where I live. And he, at one point in time, to help one of his clients with a second residence they had, or investment property they held. And so he created a limited company, set up this Florida LLC like this. And he took their house and he deeded it right into the LLC. That worked. Granted, house is now in the LLC. Well, the client receives this bill from the county, and it said that there was a doc stamp that is owing on this transfer. My buddy calls me up. He said, "Hey, have you ever heard about this in Florida before? All I did was deed a property into the LLC. Now they're trying to hit us with a tax for doing it." I said, "Yeah, in Florida, that's one of the areas where if the property is encumbered by a mortgage, then it's a taxable event when you transfer that title into a business entity." I said, "You didn't know about that. You should have used a trust." And he's not familiar with trust because many attorneys are not familiar with this tool, the land trust, because they don't teach it in law school. Most states, okay, I think probably 40 states even have a land trust statute on their books, so they're not going to be familiar with the tool. Now, it's recognized in all 50 states, the land trust is. And in fact, just 2 weeks ago, we dealt with an individual in California who was challenging the use of land trust in that state. And they said that California doesn't recognize them. And so I actually sent this individual from the Department of Revenue of California a 3-page memorandum that they released several years ago recognizing land trusts, describing how they work in California, and there was case law behind it. I mean, and the client said, "Well, there's no statute on it." I said, "It doesn't matter if there isn't a statute. It's still recognized as an entity." So the land trust, going back to this one, the way it avoids transfer tax is the case, because in Florida, if you were to put that property in a land trust like this, non-taxable, and then move the land trust into the LLC. So that's again why we're going to talk about this entity, why it's important. A land trust has multiple uses and provides anonymity. So how does that work? All right. So with a trust, it's a title holding. That's all it is. With the exception of Florida, there is no asset protection with the land trust. And what do I mean by that? Is that if this land trust holds a piece of real estate and you set it up where you're what we call the beneficiary of the land trust, meaning you own the trust, then if anything happens with that trust, the creditor that sues the trust, right? They come right here. They sue the trust. Then claims they have against the trust can be brought against the beneficiary themselves. They can go against the trust and then right against the beneficiary. So there's no asset protection. Now that is a concern for a lot of people. Now, the only state that does not allow that is Florida. Florida is the one state where you can create a land trust, and by their statute, the beneficiaries are protected from an inside claim. Now, on the outside, if you get sued as an individual, there isn't a single state out there, not a law that I've ever been aware of, that if you're sued personally and a judgment's entered against you, that a creditor cannot proceed against your trust and take your assets from you. So the land trust doesn't offer asset protection. It's a title holding vehicle. That's what I mean by it. It's a title holding vehicle, holds title to the property. I mean, you think of it like, let me give you an example, like this cup right here, right? So this is trust right here. And then what I'm going to do is I'm going to take this piece of represented by the key and I'm going to put it into the trust. Now that it's inside of here, okay, it holds title. Wherever this goes, if I were to give this to you guys right now and you accepted this, then you get whatever's inside of it. And so all you have to do is take it out because you hold on to it. So that's what I mean by a title holding vehicle. Somebody came after you, no asset protection. So what we're going to need to do then, or the way we set this up to protect us, is we want anonymity. That's one of the features that come from a land trust. Besides due on sale protection, banks not alerting the fact it's been transferred into a business entity, avoiding transfer taxes, but also it can provide anonymity if it's set up the right way. So when you're establishing your land trust, there's a couple different players involved that you need to be aware of. Two. You have one which is called the trustee of your trust, all right? And that is that holds, I say person or entity, holds title. The trustee holds title. And there's also the beneficiary. And the beneficiary is the person or the entity or whatnot that actually owns the trust or owns the property and controls it. So the beneficiary, think of that as owner plus control over the asset. So those are the two participants in a land trust. Now, for anonymity purposes, this is the one we're concerned about. See how I say it in there, it holds title. So I've seen people create land trusts and they think that somehow magically by setting up a land trust, they're going to have anonymity. And they'll go out, get a form they download, and they'll create this trust. And you can do it. I mean, if I wanted to right now, we could sit there, we could take a book like this, and I could create a land trust in about 3 minutes. Now, it's not going to have all the provisions you wanted, but that's how easy it is to create a trust. It's pretty simple. You're going to be missing important provisions, but you can create a trust in about 3 minutes on a napkin if you have the right parties involved in the right verbiage. Well, the issue that comes into play here is that if I'm doing this, let's say I create my trust, and it's just me, then I'm going to list my name as the trustee. So the trust would have trustee. And then I'm going to also list a beneficiary, the owner. Well, since it's my property, I'm going to be the initial. I have Clint as Benny. So I've got my property, and I'm going to deed it into the trust. And let's just call this the Green Trust. I deed it from Clint to Clint as trustee of Green Trust. Where the heck's the anonymity there, right? I mean, even an attorney, okay, can figure this one out. That Clint owned it, and now he owns it as a trustee of a trust. No anonymity there. So when you're creating the trust, you see where the problem lies. If you want anonymity with a land trust, you got to do something about Clint or whoever it is, you're the owner of your property. You don't want to be your own trustee, because if you're your own trustee, the property is going to go from your name into your name as trustee. So the way we fix this is we got to come up with a new trustee. So what are some of my options then when it comes to using a trustee? You can use what we call a nominee trustee. A nominee trustee is someone other than you that you trust to serve in that capacity for title holdings for that deed transfer. And then they resign and they appoint you, or the trust actually does this. The trust states that should the trustee resign for any reason, then we appoint this successor trustee of the trust. So a nominee trustee person that's going to serve there for title purposes and then resign, and then you're going to step up into that position. So when we create our land, we give our clients this option. Do you want to use a nominee trustee? Now, in Anderson, I am that person. I'm on thousands of land trusts where I'm listed as the initial trustee. So property has been transferred into my name. And this happens whenever I buy real estate that I have to finance. If I'm using it, they'll come back to me and they'll ask me, and this I pretty much figured out, it's about 7 days before closing. They run a search and they find that I'm on all of this real estate and they look in the state and several counties and they'll say, hey, you're on 375 pieces of property in Maricopa County and you didn't disclose that to us. Well, it's because I don't own that property. But see, the thing that I do, because all they see is I'm on title. So what in this situation, what we've done with, hundreds, thousands of individuals is we've taken their property, or they've elected to do this. They've taken their house, we set up this green trust, and we put on the Clint as trustee, and they actually moved the property out of their name and into my name. In fact, anybody that's on here, if we've done that for you, just say, hey, yeah, Clint did this for me. And the reason I say that is because when we moved it into name, initially people, right? Because what happens is they think, well, if Clint's listed as trustee, he could sell my property. He could refinance my property. Heck, I might even move into your property, right? Not, okay? I have no interest in your property. Putting me on there, you list me initially as your trustee, so it's no longer held in your name. So if this was Karen, so on title, Karen used to be listed there. Now it's going to say trustee of the Green Box Trust. That's how it's going to read. Now, once that takes place and the deed's signed, putting into my name, I immediately resign my position. Immediately. Now, if some of you are thinking, well, how do we know Clint's going to resign? He may be telling us that, and we've seen him on videos, but maybe this is how he's building his real estate empire, by getting unsuspected real estate investors to transfer him all of this real estate. And then he's just going to quit, disappear to Belize, and collect all the rental income for the rest of his life. Okay? Well, the reason, if I didn't resign, you hire me. Okay? You have control. The reason you have control is because Karen is the beneficiary. Remember I told you the beneficiaries have control over the trust? Part of that control is you can fire me. So if I don't resign, you just fire me. And fire me, who are you going to appoint as trustee? Yourself. Well, I resign my position. And the reason, beyond just the moral aspect of it, and I'm not building my real estate empire through this. The reason I resign as well right away is because I don't know what's going on with that property. I've never been out. I am more concerned about your property than you would be about me, because let's say that property was a grow operation. In fact, this actually happened. Been practicing for 3 years, and this elder drove from Eastern Washington to my office. And they wanted me to set up a series of structures, land trust, LLCs, that protected their identity to own these various rental homes that they held in Spokane, Washington, and this farm property. And one of the things they related to me was how profitable all of their operations were. So we were looking at their tax returns. I said, okay, great, we can do something like that. And we started the paperwork, moving forwards and collecting some information there. And then they went radio silent. I couldn't get a hold of them. My secretary's reaching out, and she can't get any information out of them. Well, an intern brought me an article, and then I think it was in the Spokesman Review or something, about the largest drug bust in the state of Washington. And guess who it would happen to be? This husband and wife that were in their late 70s that came over to meet with me were running the largest marijuana operation. And what they had hired us to do is they wanted to get their name off of title, and they were trying to set me up to be listed as the initial trustee. I saw what was going on. We figured out then, and it really struck home with me. You have to be careful. I got to resign immediately. Get off this stuff before anything happens. And that's why before the documents go out to our clients after they've signed them, I resign and I appoint you. Well, actually, the documents appoint you as the successor trustee. So when this title's transferred into Clint, property's right there, then what happens? I resign and then Karen steps in. But on title, no one sees this because that's a private document. Now, when I resign, what I also provide Karen is what's referred to as a trustee's deed, which means this. It's a recordable deed. So when Karen needs to put her information on title, now this is important. You got to pay attention here, because if you do this, you always have to get a trustee's deed from that nominee trustee if you're going to use someone like this. Because if you want to sell or refi the property, you need your name listed on the deed. Because if you're not listed as deed, then it's going to make it extremely difficult for you to do that. Go into a bank, hey, I want to refi this property. And they're going to look at it and they're going to say, well, who the hell's Clint? That's a guy that I used to hide my own. Again, that argument, why are you hiding the ownership of your property? What are you doing? So you need to record the deed, and Karen then has to drop her anonymity shield when she's looking to refi or sell. So you always need that trustee's deed for that reason. So until you're ready to do something, title is going to continue to be held in my name as trustee. Now, your goals of benefit. The other things you need to be aware when you do this, property tax statements. This is where I've seen people run into problems. They want to use a nominee trustee. They don't use our firm. They're using their friend. Big mistake using a friend. Because if that friend is involved in a lawsuit, those individuals are going to assume that that friend owns this piece of property, and they're going to go after it and cloud title for you. So you want a professional in that capacity, preferably an attorney. As the attorney push back and say, no, this is attorney-client privilege. It's my client. I'm doing it for them. I'm serving as trustee. I don't know who. I can't give you information on that. So there's a strong concern why you would do that and not use a friend. I've had clients that have tried that strategy before, only to cost them thousands of dollars in legal fees because of what the other guy did. So that's always use a professional if you're going to go down this road. Second thing is the property statements. When you transfer property into a trust, you have to then get a preliminary change of ownership form, whatever it's called in your state, to say where you want your property statement sent. Well, when we set these up, we have them sent to our office. We receive hundreds of property tax statements every month. And then we turn around and send those out to our client. But if you send them to yourself, right, they come in and they go to your personal address, how I can track you. So property could be held in Clint Coons, trustee of the trust, but if the property tax statements are going to Karen's house, I'll just look that up, and then I know it's her property. So that's a issue here. So when you set up the land trust, you don't want your name as a, you want to either use a nominee trustee, someone other than you, preferably an attorney, and you don't want to use your address. You got to use another address, a P.O. box or a firm like us to forward the mail to you. Option number one. Option two, to obtain anonymity for your real estate. And that is to use an LLC. And this is going to be an LLC that does not list your information. Can you think of an LLC or a state where it doesn't list your information? Absolutely. Wyoming, where? Remember I said New Mexico, I can use them occasionally? Yeah, we could even use a New Mexico LLC here if you'd like to do this. So in this case, what we're going to do is Karen would do the exact same thing in the prior situation. She's got her house over here. She's right. She's listed as the beneficiary. And if I didn't say it, beneficiary, this trust, it's a private document. So it's not recorded anywhere that someone could pull and all these parties, who's involved. None of that's disclosed. The only thing that's disclosed is the trustee's name. So when I create my trust, I'm going to have the blue box serve as a trustee. So blue box is trustee. So now when I record my deed, I'm going to transfer it from Karen into blue box trustee of the green box trust. Now the advantage of using the blue box is that you don't have to go through that trustee's deed like I just described. You don't have to have someone resign because you're immediately in control from the outset through your limited liability company. And you only do this for your own property. And the way I'm up, the trustee, the LLC cannot receive any compensation or remuneration for being a trustee. Those are key components here. But you're set up this way, so now you've got your LLC that's controlling in the future. You don't have to deal with a third party like myself to handle anything, or maybe you lost a trustee. That's no longer an issue for you. So this is another way in which to structure it, and we do a lot of this now. And the reason why we've gone down this way is because what happens many times is that even if I give a client a trustee's deed, tell them everything they need to do, you forget. You get preoccupied. And our clients will then go into a bank refi, list the property for sale, and then we have to back everything out and restart the process because when they pull it, they see my name there and they didn't file that trustee's deed. So this is why I really like this strategy. There are benefits of having an attorney there for sure, as far as privacy concerns. For example, There was last year I was served notice. There was a foreclosure going on a piece of property in Riverside County. And the attorney served me because when he's handling this foreclosure and he pulled up title and said Clint Coons, trustee of this trust. And he served me notice because he has of the foreclosure sales as the representative of the trust. And I called him up and I said, you did not effectuate proper service for this foreclosure action on me. He said, what are you talking about? You're the trustee. And I said, no, I resigned. And then his next question was, well, who is the trustee? Well, I said, well, I'm an attorney. I can't disclose that to you because it might be my client or it may not be. Oh. And I said, you have to figure that one out on your own. And he was really upset. Well, this is messing up my, this is a problem for me. And I said, you're right. It's your problem. It's not a problem. But that's the way it's designed to work, unfortunately. For him, fortunately for us, it makes it more difficult. Whereas if it was the LLC, you could come right at it and then you could effectuate the service or process. There are some benefits to having an attorney there. You have to weigh that out yourself. Now, once you have that up, of course, you've got your green boxes and your properties inside there like this. You're listed as the beneficiary. Typically, we structure it this way initially because when you're transferring the property, if it's financed, we got that due on sale clause. We want to make sure that it's just going into the trust. When we file the change of ownership form with the county, some counties want to see a copy of the trust. We don't want them to think that there's been a change in who the owners are. So it's important to start off this way. And then after everything's done, that's when you can bring your red box back into the picture and you can assign. Okay, that means just transfer your green box into your red box. So your structure will kind of like this. I can draw it another way. Sometimes people find if I do this. Here's your LLC. Here's your green box right here, owning the property. And if you have that blue box set up like that, and you're down here. Now, we'll talk about taxation of this next Saturday during the event that we're going to be having, but that's how that structure would appear in a little different visual representation of it. And this is going to give you the anonymity. There's going to be anonymity here with the property, anonymity here with this red box. There's going to be anonymity here with the blue box. No one's going to see you down here because you're not tied back to any of these particular boxes. And so this is how we go about creating it. It's methodical on the approach. You want to make sure that, it's very difficult for someone to do this on their own. Because if you're not leveraging the services of a company that sets this stuff up, it can be problematic in the overall creation of it. So you want to make sure you're doing it the right way, and then you can build yourself out a very effective. Because by not doing it, there are severe risks that come from it. And I'll leave you this one last story, and let's take some questions. So this individual in California, they'd created a limited liability company to own their real estate. And this is why people say you don't need anonymity. All you have to do is put it in an LLC, and that it's all hocus pocus stuff that's about. It's not. This is real world litigation, how somebody loses assets because they don't appreciate this. This individual has this limited liability company that owns a rental property. He transferred the rental property in 5 years before what occurred. He then borrows some money personally, and he doesn't pay it back. So they come after him and they obtain a $75,000 judgment against him individually. Now, they get this $75,000 judgment against him, and if you have a judgment, you can then take that judgment and you can use it to levy on specific assets that a person may have. For example, if you own rental real estate in your own name, I record that judgment wherever I can find real estate that's listed name, and it'll stick right away to that property. So if you sell or refi, I get paid. If you have a bank account, I can garnish your bank account, take that money out of your checking or savings. If I know about it, I can get paid my $75K. Well, they couldn't find anything on this guy. And the reason why is because he didn't have any assets besides this one LLC with a piece of property with maybe $200,000 equity inside of it. And what he process of doing while all this was going on, he was trying to do a cash out refi as well out of this property. Well, they ran an asset and they found that he owned a red box. So they tracked his name to the LLC. So once they saw that he owned the LLC, then they wanted to know, does the LLC own anything? So now they went back, and rather than running his name through county recorders databases, they red boxed through the county recorders databases, and they got a hit. and they found that it owned a piece of property. Now that they knew it owned a piece of property, they moved against him, and they put a lien, a prejudgment writ of attachment. They filed a lien on that. It's called a lis pendens, essentially what they're moving for, against that property. They filed their lis pendens, and he had 7 days in which he had to court to argue whether or not they had the legal authority or right to do this. And he called me up and he goes, "What do I do?" And I said, "Well, you're going to have to get an attorney." And what screwed up is he couldn't do his cash out refi now. And he was complaining that the LLC didn't protect him. He said, the LLC protects you, but you didn't know how to protect yourself from this type of stuff. And that's the techniques that attorneys can use to put leverage on you to force you into a settlement posture to give them what they want. He could have easily, had he set up a blue box here, it would have never have occurred. And he would have gone through that refinance and got his money. So right now, what I'm going to do is go through and all some of these questions that some of you have been posting. I may not be able to get to all of them, of course. I know there's been quite a few coming in. I'll try to get to a few here. So let me see here. Home investor, can you confirm a land trust in Arizona? Statute states that cross-party can void the deed. Oh, so this question right here that you see up here to do with Arizona. And it comes up quite a bit. I don't know if you can read the background on this. Let me see if I can change that to white. People want to know, if they've been told that if they property into a LLC in Arizona or land trust in Arizona, that the party transferring in can void it out. And that's true within, I think it's 3 years. The person moving the property into a land trust or a trust that does not disclose the beneficiary of that trust has the ability to void this. Dealt with it this week. Now, the person is going, well, then it's not an effective transfer. I said, wait a minute, think on this. You're transferring the property into your own trust. Are you really going to go back later and void your own transfer into your own trust where you're the beneficiary and you wanted anonymity? That is insanity. Why would you do that? It's like, oh, I never thought of it that way. Exactly. So when you read this stuff, it can be confusing. Somebody wanted me to put the link back up. Sure. Here's that link. Event next week. It's aba.link/June TAP. And it should also be in the comments. If somebody else can, one of my staff could post that, it'd be great back in there. Would it be a good idea to have a living revocable trust on my estate, then have a manager manage LLC own the trust, or is this not a good idea? Okay, so living trusts, they're typically not, it's not going to be owned by an LLC. LLCs are owned inside of living trusts. It's not the other way around. So the living trust is important. I've got some other videos on my channel talking about this. Have one, but it's not going to be something that an LLC wouldn't own a living trust. Okay, what else do we have here? Disney was unable to expand land when people found out he was buying land prices. Yeah, this is great. Disney World, they use land trusts to acquire quite a bit of property down there, for very cheap prices because they kept that private. Already answered that one. Are there ways to transfer property from an S Corp to an LLC over time without creating a taxable event? That's difficult. That's something we'd have to talk about one-on-one on how to do that, because you're right. If you have an S Corp and you try to pull it out, that can create a taxable event for you. All right. Can a land trust owned by LLC owned by a Wyoming corporation? Yes. So when I was drawing this out earlier, and I stated that, let me just take this back down, and we're putting together like this, you know, and I was putting this into a blue box down here. You don't have to go blue box. What you're doing, you could, if it was a flip or something like that, you could have a corporation here owning that structure as well, and you still get anonymity. This is one of the things that I teach in the flipping side of the active investing side. Depending on what you might want anonymity on some of your flips. Next Saturday, we'll cover this in detail, but that's something to consider. You can do that. It does not have to be just inside a a limited liability company for holding purposes. It could also be for flips. So it's beneficial as well. Is there a difference between a living trust and a land trust? Yes, there is. The living trust cannot be assigned to another party. If you want to assign the interest, you have to pass away. So I'm not into that, at least not yet, right? So you want to use a land trust because it gives you the ability to move it while you're alive. That's the way to go here. So we got a couple of questions on that. Are trusts part of the services in the contract with your law firm? Additional fees involved in each trust. You can contact us on that. We have a land trust package where we do unlimited land trust for individuals, or you can do them individually. But yeah, we do set these up, and we know how to do the deeds, and we perform all the deeds in about 40 minutes as well. Great, thank you for all the videos. So land trust does offer asset protection in Florida. So here's a question here. It says that when you transfer real estate, when you transfer real estate from your personal name to an LLC, does that eliminate anonymity now for the LLC holding company? So when you transfer from your personal name to the LLC, it's not going to eliminate the anonymity because it looks like you sold the property to someone else. So that's not going to be an issue. But if you're concerned about that, then yeah, you could use a land trust as well to put that structure together. So this is a good question, and it's something to consider. From a land trust perspective, if you want to cut an additional tie there that someone could try to piece it out, use a land trust. When you get anonymity, if you're setting up a QRP with a corp owned by, can you obtain anonymity if you're setting up a QRP with a corporation owned by a Wyoming LLC? Jay, you can do a lot there when it comes to anonymity as far as asset protection is concerned with QRPs, but we have to be careful on how we're structuring that. And this isn't one I'm not going to go in too much detail, but the answer is yes, you can. You just has to be done right. Typically, how much should one pay for a land trust? Well, that's going to depend on who's setting it up for you and what services are being provided. It can range anywhere from, I've seen, $750 all the way up to $4,000 or $5,000. Some people will charge for land trusts. I think pretty excessive. We have, like I said, an unlimited land trust package that ranges from $2,000 to $3,000 depending on what other things we've done for you. But normally it's about $3,000 for unlimited to set that up. How do you protect Okay, so here's a question. How do you protect the identity of the trust that owns the Wyoming LLC? Well, the way you protect that is that no information is provided about the Wyoming LLC, so that is kept completely private. So no one will know that you're involved there. What are your odds on filing a UCC1 for an LLC owned by a trust for your personal assets? Could this prevent someone from receiving a judgment? Great. This question right here, I teach a strategy on that. We may get into it next week, but UCC1s, for those who aren't familiar, it's a way to encumber your assets. And if using anonymity, you create a blue box in Wyoming. Let's say you do this if you had a business and you have assets you want to protect. So you got this blue box over here. And you could also do it with real estate, by the way. So it works in many, but that we call a friendly lien. So if I've got this blue box here and I have my orange box over here, you end up, let me get this off here. You end up doing this. You end up having this entity file this UCC1 statement, and it's attached to a line of credit between the orange box that you own and your blue box, and no one knows that you own the blue box. So it looks like the blue box loaned the orange box money, and then by filing the UCC1, it encumbers all of the orange box's assets under this statement. So it's accounts receivables, it's cash, bank, all of its equipment. So it's an interesting strategy. We utilize it. Also, you can use what's called a friendly lien for anonymity purposes. Again, because no one knows you're in charge of this blue box, it gives it more. I hate to use ability, but the reason I'm using it, if somebody looks, they don't see you on both sides of the transaction. So if you had a red box over here, and maybe it had a land trust, and it owned a piece of property with a ton of equity, you can have this entity here file a second deed of trust or a first deed of trust against that property to suck up that equity, make it appear that there's nothing there available for it. And so that's, again, we'll cover that hopefully next week if I have time. A strategy, it's called equity stripping, friendly lien, different ways people will describe that. 1031 exchanges with both spouses, how to get title, to get asset protection, you disregard any for same tax on 1031. Okay, so if you're going to do a 1031 exchange, you would do it straight out of the entity itself. If you hold it in a tenant in common relationship, it could be a little more complicated. If no one wanted, if you had an LLC and both parties don't want to go through a 1031, then we have to do something a little different with that. But you can engage in 1031s inside of entities. All right. How do they get a bank account for a land trust? Well, in order to do that, you're going to need to obtain an EIN. And so we would apply for an EIN for your trust. I've heard land trusts can be difficult in Pennsylvania. You are absolutely correct. Land trusts, if you try to use them in Pennsylvania, if you try to use the traditional land trust there, then that is a taxable event. So if you live in Pennsylvania, you have to get a little more creative. We're not going to go into that on this live one. And then thanks for all the great info. Can a gift deed be used when transferring rentals from personal names to a real estate LLC? So you want to definitely file a deed. Typically what we're going to file is going to be a grant deed, a bar sale deed, or something like that. I want to make sure that you preserve your title insurance at all costs. So the type of deed form we're going to choose is one that will not void a title policy when the property gets transferred in. You've seen some of my other videos where that has been an issue for clients who've done this work on their own, and they screwed up a title policy. And they found that out when they tried to sell it because there was a missed encumbrance. So you got to be really careful there. I have a rental property in Alabama that was going to be part of my grandfather's estate. My grandfather passed, and I'm on the deed. Should I transfer the home into an Alabama LLC and have the Wyoming LLC be involved there? Yeah, definitely do that. Now that if you're on title. Now, if you're not on title, so here's something to consider. You got to make sure with the transfer taxes. So this is a really good question from Michael that he posted. So Michael, somebody passed away. He's the beneficiary of the estate. Now, Michael could take title into his own name and then set it up into the structure. But Michael, you may want to consider to do this. Set up the structure while it's part of the estate, put the property into the structure so it never hits your name, and then take the structure into your name. So now you take the LLCs. That's one way to keep you off of title rather than distributing it to yourself directly. Great question. Great question. So, and then have the Alabama LLC own the blue box. What about transferring automobiles to a trust? What kind of a trust would this be? You can use a personal property. If you want anonymity for personal assets, set up a PPT. That's it. Interesting you brought this up. A couple of years, oh gosh, you get older, everything seems to be like a couple of years ago. 12 years ago, one of my, an individual tried to steal the title to her vehicles. They did steal the title. They tried to take the vehicles, actually. They showed up at her house one morning on a Saturday claiming that all of her vehicles belonged to this third party. And the person showed up, obviously was crazed, and they were trying to commit theft, but they had all the title of the vehicles, and they said they were going to call this, that my assistant had stole these and that they actually own them. It was for the one thing that her husband said he's going to go grab his shotgun, this person to leave. Turns out that they had gone online, they got some information that was publicly available, transferred the title into their own name. Now, that is a problem potentially in some states. So with the way we solve that for this individual is we set up a personal property trust. Remember that box I showed you earlier? We set up a personal property trust for her, and we retitled all the vehicles in the personal property trust. So if anybody searches title, they'll no longer see this particular individual, my assistant or husband, that vehicle just shows up in a trust name. So yes, you can do that. How would one apply as a successor trustee or beneficiary? So I'm not sure what you mean by that, but just create that when when you set it up. And oh man, guys, that's about it. Again, check this link out. I got part of the things about having an office downtown here in Tacoma. You have individuals show up that shouldn't be here, and I just got a quick text from my that I've got a transient undesirable in our building, and I got to go take care of that. But anyways, hey, thanks for being here. Check us out next weekend. I'll be there all day on Saturday, and come to that event. All right, with that, I'm going to part, and I hope to see you next week. Thanks, everyone. Bye-bye.